Oh, I suffer from toxic masculinity. Absolutely not. I cry
She
when
hit me when I started crying. Yeah. Said, get those tears back in there, boy.
I cry in movies and yeah, I obviously cry in real life too, but this movie, it still makes me cry.
Taylor may have had some influence in getting. Yes, she did. Yeah, I know. I don't even know if I'm meant to be saying it, but I'm saying it. Yeah, she was a helpful part of the process of the audition, which I found out later after I got it, and that rocked my world.
Besties, Blake Lively is playing games in court. You know how she's been accusing Wayfarer of playing games? Well, apparently she's the one playing the games because last week she filed that motion for a protective order, trying to claim that Wayfarer keeps bringing Taylor Swift into this and that she doesn't want to hand over her text messages with Taylor Swift to Wayfarer, and she doesn't want Ryan Reynolds to hand over those with Taylor Swift, or 8 and 9, which have to do with what Lively told Taylor about the film and what she might have told Lively about the misconduct that happened on the film. And she doesn't want to hand over it all because she claims that, Taylor might have given those documents to her to Wayfair, and so she shouldn't have to. And she also then said that even if they didn't get them from Taylor, she shouldn't have to hand them over because they're irrelevant and because apparently Taylor knows nothing and she is not a part of her lawsuit. And she said all of this with a straight face. And then she also claimed that she had a meet and confer with Wayfair and they refused to talk about these documents about Taylor Swift. That's actually not what happened, according to my favorite attorney. Who's that? Oh, Kevin Fritz. I know a lot of you guys love Brian Friedman, but I have a thing for Kevin Fritz. He is scorched earth kind of man. So Wayfair responded not only to the protective order, but they're also doing a motion to compel in conjunction, which is a cross motion they filed, and they're seeking documents because Blake has apparently provided nothing. They provided a declaration by Kevin Fritz. They provided the initial disclosures, which also has names of lots of people that might be interesting to you to hear, of individuals that have relevant information about the claims in these lawsuits, including some celebrities like Bradley Cooper. And they are arguing that she has produced nothing related to SH and retaliation, her communications with Miss Swift, Sony, and WME concerning the same, and her claims for economic damages, which are responsive to certain requests for production. So she has been crying about how she didn't get anything from Wayfair, and then she did that whole thing about how they needed to prove damages. She has yet to prove damages to them. And they claim that Lively is bound by her initial amended disclosures, and she contended that Miss Swift is in her letter for the protective order. She said she contends that Miss Swift is not central to Lively's claims and that the only allegations that were ever remotely relevant to her were in the Wayfair party's now dismissed complaint. And it requires parties to disclose the identity of each individual likely to have discoverable information along with subjects of information that the disclosing party may use to support its claims and defenses. So they provided initial disclosures, which identified Taylor Swift as having percipient knowledge as to the facts and the events alleged in the pleadings. And then in her amended initial disclosures, which she served a week ago, she amended her initial disclosures a week ago. She identified certain individuals who she believes to have discoverable information on her claims, and then they redacted everything and they certified that it was complete and correct, and then she admitted that it's all redacted. I'm assuming that she put Miss Swift on there, but she's required to produce non-privileged communications with witnesses identified in her amended disclosures. And she's publicly stated that Miss Swift was with her on the experience the whole time, all throughout it. She lived this with me. In her motion, Miss Lively does not contend that the production of her communications with Miss Swift relating to It Ends With Us and this action is disproportional to the needs of this case. And they also say they're relevant to her garden variety alleged emotional distress. She's claimed that she has suffered from all kinds of issues, and they cite a actual case that was ruled on by the judge in this case, where they had to turn over text messages with a friend, and they wrote, Miss Lively recently withdrew her claims for intentional infliction of emotional distress and negligent infliction of emotional distress. And thereafter, she stated that she still pleads and intends to produce evidence of garden variety emotional distress in connection with other remaining claims. As part of her remaining claims for harassment and retaliation, she alleged that she has suffered and continues to suffer from severe emotional distress, pain, humiliation, embarrassment, belittlement, frustration, and mental anguish. In an order on June 10th, the court confirmed the dismissal of the IED claims, but it did not preclude her from offering evidence of garden variety. So they're basically saying that if Miss Lively and Miss Swift socialized after the alleged incidents at issue in the case, as have been reported, they're entitled to relevant communications to disprove her purported emotional distress. So they're looking at to disprove it. And then they say they rely on a Daily Mail reporter who had quoted an unidentified insider as stating that the Wayfarer parties obtained unspecified information from Miss Swift, and Miss Lively should not be compelled to produce relevant communication with Miss Swift in her own possession. It says that she does not cite any legal authority for this proposition that such double hearsay is proper basis to preclude the Wayfarer parties from obtaining this discovery, especially information that they believe will basically exonerate them. And then counsel for the Wayfarer parties and Miss Swift both confirmed that no communication between Miss Lively and Miss Swift have been provided to the Wayfarer parties. That acknowledgement, which Miss Lively is unable to contest, refutes her contention that the discovery sought from her is duplicative and warrants denial of the motion. For good measure, even assuming the Wayfarer parties had received relevant documents from Miss Swift, which they have not, such hypothetical fact does not relieve Miss Lively from complying with her own obligation under Rule 34 to produce documents in her possession. So they didn't get any communications directly between Taylor and Blake, is what they're saying. And they're saying that Blake knew that. And Blake is trying to argue that since they had it, they need to not ask her for it. It's not even a valid argument. But they also go on to say that she has not provided any documents whatsoever to prove her damages, her allegations of SH and retaliation, and her communications with Sony and WME. And the stuff with Sony and WME has to do with Baldoni, and it has to do with the film, and it has to do with his contract, and it has to do with if she told them anything about what was going on. And they said that they did a produced documents on a rolling basis does not entitle her to withhold relevant information that speaks to the heart of her allegations until the deadline for substantial completion of document discovery. They want the court to deny her motion, which is the protective order, and grant their cross motion and direct Miss Lively to immediately produce documents responsive to requests within her possession. Although we appreciate the positive influence Miss Swift's music has had on her worldwide audience, it was Miss Lively, not the Wayfarer parties, that contemporaneously inserted Miss Swift into this dispute, and Miss Lively cannot use Miss Swift's stardom to withhold evidence. They also put a footnote in there, which shows Taylor and Travis and Blake and Ryan out to dinner in October of 2024 as proof that they saw each other and socialized after this alleged retaliation. They also footnoted a video of Blake bragging about how Taylor was with her every step of the way through the movie. So, what I thought was interesting here is that Kevin put a declaration here and he further outlined what occurred here. And all I see here is gamesmanship. And it says that they are submitting it for a cross motion for to compel her to produce documents. It says neither Miss Swift nor her counselor have provided Wayfarer parties with any communications between Miss Swift and Miss Lively. Now, it doesn't say that they didn't get anything between Miss Swift and a lawyer. I don't know. They just don't have the communications directly between Swift and Lively. And they said that on May 22nd, 2025, Miss Swift's counsel notified Miss Lively's counsel that no communication between Miss Swift and Miss Lively had been provided to Wayfarer parties. No documents are being produced and no deposition is being scheduled. Therefore, when Miss Lively's counsel demanded the same day at 4:57 p.m. that the Wayfarer parties produce documents obtained from Miss Swift or her counsel concerning Miss Lively, they already knew that no such documents were in the Wayfarer party's possession. And then an email delivered on June 12th, and in accordance with Rule 4C of the individual practices, I requested that Miss Lively's counsel meet and confer telephonically the following day at 3 p.m. about the requests, which include request numbers 108 and 109, seeking Miss Lively's communications with Miss Swift. The statement by Miss Lively's counsel in her declaration dated June 13th, 2025, that the Wayfarer parties have still not made themselves available to meet and confer on this issue is inaccurate. In response to my email, they confirmed on June 12th that they will be ready to discuss the parties' productions as needed. Minutes before they scheduled meet and confer on June 13th, she filed her motion. Given Miss Lively's prior representation in her formal discovery responses, the motion was the first time she advised the Wayfarer parties that she was refusing to produce documents responsive to requests. So remember how I said that narcissists love to run to court first to get ahead of something? So she filed a protective order on the 13th, knowing that they were going to demand that she produce this at the meet and confer. Her communications with Swift, along with her documents related to damages. So instead of having that conversation, she files a motion for a protective order, and then apparently at the meeting then wouldn't talk about it. And it says during the telephone call, her counsel refused to discuss requests 8 and 9, her communications with Miss Swift about the film and action, because moments earlier she had filed the motion. When Miss Lively's counsel was reminded that I had requested, in accordance with the individual practices, that they meet and confer about the issue, they again refused to discuss the issue and stated that I could oppose the motion. When I suggested that, notwithstanding her premature filing of the motion before parties met and conferred, the parties should discuss 8 and 9 to resolve the dispute and moot the motion, and she still refused to engage. She made it seem like they didn't respond to her, and that's why. And they said that they didn't want to talk about it, wouldn't say anything. During the telephone call, I explained to her counsel something that they already knew, that Wayfarer parties are entitled to communications between Miss Lively and those non-parties identified by her initial disclosures as having discoverable information. So she, Blake, put Taylor Swift on her disclosures. She told Wayfarer that Taylor had relevant information, but she's been acting this whole time like Wayfarer is the only one that's doing this. The requests were included within Wayfarer Party's first set of requests for production documents and things to Lively dated February 21st and March 25th. And even though 10 weeks has passed, and even though the parties agreed to make rolling document production, she has not produced any documents responsive to the requests. For the requests pertaining to allegations of sexual harassment, her communications with Sony and WME, her talent agency, and documents concerning her alleged economic damages, her counsel refused to commit to a date for the production thereof and merely stated that they would be produced prior to July 1st. So she's been running to the court nonstop when Wayfarer won't give information before July 1st and crying about it. And she's doing the exact same thing. And then he provided a bunch of attachments, and it's pretty obvious here that on June 12th at 4:51 p.m. on a Thursday, he said that they were available to meet and confer on Friday about Michaela Conley's email concerning our document production and about Ezra Hudson's letter concerning Blake Lively's June 23rd, 2025 deposition. So she's getting deposed next week. For the sake of expediency, please be prepared to discuss her woefully deficient document production. Even though we served our first set of requests for production months ago, and even though 10 weeks ago, she assured us via her formal responses and objections that she would conduct a reasonable search for and produce relevant non-privileged documents, she has produced nothing other than documents in quotations obtained through her company, Van Zandt Inc. So she has given them nothing outside of what she has from the subpoena. That's it. That's all. Basically, what she handed them over was everything from Jen Abel's phone. As merely a few examples, she has not produced documents and communications relating to her allegations of sexual harassment or other misconduct relating to documents and communications relating to or reflecting her communications with Sony related to the sexual harassment or other misconduct, documents and communications relating to or reflecting her communications with WME relating to sexual harassment and misconduct relating to the film, documents and communications relating to her claims for damages, such as supporting her allegations in paragraph 457 that she has suffered and continues to suffer substantial damages, including but not limited to past and future losses in earnings, equity, and other employment benefits, and documents and communications with Taylor Swift, who, accordingly to Lively's amended initial disclosures, has knowledge of the parties' alleged conduct, complaints, or discussions about the work, environment, or conduct on the set of the film, the production, editing, cut, creative process associated with the film, and publicity surrounding the film and the retaliation campaign alleged by Miss Lively and resulting damages suffered. So she did initial disclosures, and when her initial disclosures were provided, which basically is these are all the people that we think are relevant, right? She told them that and made it clear to them that Taylor had information on production, editing, cutting, creative process, complaints, publicity, marketing, and retaliation. So she made it to under these documents, she made it seem like Taylor was super involved. And that's what she told them. And so now she's all of this bull crap of her running to the public all the time and saying they're the ones that dragged her in. She gave them an initial disclosure a week ago and claimed that Taylor had all kinds of involvement, even though Taylor's reps have said she had nothing to do with this. And what I see here is that they were telling them on June 12th that we were going to have conversations about this lack of production. And if you don't talk to us about it, we're going to file a motion to compel. So what did she do? Instead of talking to them about it, she ran to the court and said, I want a protective order. I don't want to hand over these records, even though she's the one that told them that Taylor was involved. So there's either something in there that disproves what she's saying or Taylor is involved. And I don't believe Taylor has that much involvement here. And I think Kevin is on right where he's saying that Taylor, we believe she doesn't want to hand these over because it will disprove what she's saying. Like she's lying. And then they responded to this, acting all shocked. They said that parties have already received multiple productions from Sony and WME, and the Wayfarer parties and Miss Lively have mutually engaged in making rolling productions in advance of the substantial completion deadline. This is the first time you have raised a concern with the pace of her productions, and the Wayfarer parties have only made 2 voluntarily productions or 3, including the compelled production. She has produced 2832 documents, and all of the Wayfarer parties collectively have produced only 754, including what was compelled. In any event, she intends to make her next production tomorrow and to make regular rolling thereafter. And then he said, please let me know if all the documents responded to these categories will be in tomorrow's production. And then she didn't respond and instead ran to the court for a protective order. So she knew that they were going to compel her for this and she didn't want to give it up. And I would guess that a lot of the documents that he says that they've received came from the subpoena she issued on Stephanie. And if all of it has to do with what Wayfarer did, it doesn't help them prove their defense or prove her claims. What it says to me is that she has provided them nothing. Like Sony's given them stuff, WME has given them stuff, but Blake has given them nothing. They provided a list here that they filed, and it was their initial disclosures. And it was a list of all of the parties that might be aware of what's happening in this case. And it has, nearly everyone from the film. It has Blake and Ryan on it, all the normal parties you would have thought. It has a bunch of people from Sony. It has basically the entire cast of the film. It has most of the crew of the film. It has people from WME. It has the intimacy coordinators. Colleen Hoover is on here. Her manager, Justin Greystone, is on here. The editor she hired, Shane Reed, is on here. But I also noticed that Bradley Cooper is on here. Why would Bradley Cooper be on here? That's so strange. And then Taylor Swift. What I think is interesting is that she has routinely, Lively that is, publicly through her attorneys over and over and over again told the public that it was Wayfair that was bringing in Swift. But according to that email from Kevin that he sent to her attorneys last week, she had only just sent them an amended initial disclosure where she included Taylor's name on there, and it was signed by her attorneys stating it was true and accurate, and she's telling them that Taylor has this huge role in it, even though publicly Taylor has said she had no involvement. So it's she keeps trying to flip this like it was it's Wayfair that's using Swift. It's Wayfair that's doing this. It's Wayfair that's doing that. And they basically just exposed her, finally. Thank God. And they exposed her games that she's playing, how she was going to have to talk to them about this. And instead of talking to them about it, she filed a motion because then she can put the motion out into the public for more press. It's just such a game to her. It must be so frustrating to be on the receiving end of her crap. And then her attorneys that are behaving this way seems so unethical. It just doesn't seem like her attorneys are playing fair. And I don't know if it's because her attorneys are being directed by Blake or if this is just how her attorneys act. But if I were involved in litigation with her attorneys and this is how they acted, I would be going bananas. And I have been involved in litigation where the opposing party refuses to produce anything. I mean, I think I've told you all that I waited for years for someone not to produce any documents related to damages, like 0 documents, years, multiple motions to compel, orders from the court, and they gave us nothing. So I see so many similar patterns here, and the fact that she's trying to make it seem like they're not doing anything when she's not doing anything either. I mean, it was only 2 months ago that she was demanding them to prove damages, and yet she hasn't proven any damages. And then she's trying to rely on Sony and WME to produce, who are third parties, by the way, as evidence that she shouldn't herself have to produce. It's bananas. And then they also exposed another lie. So yesterday, she sent that letter to the court, and she basically said that they hadn't produced any emails and only Tag had provided information, and it was very vague. And Tag didn't make clear if they had any emails to again try to put out a narrative to the public that somehow they're using these clandestine communications. And again, Kevin Fritz, who's been very busy today, made clear that Lively parties acknowledged, as promised, supplemented its response to the interrogatory. Although the Lively parties feigned confusion over Tag's one-word answer, which is none, Tag's response confirmed that there are no email accounts as to which it provided to any form of access to third parties. This aspect of the motion is moot. They don't have any documents to prove that they used these emails. This was just a stupid theory that whoever came up with, probably Mr. CIA man, and they tell her that they don't have to respond to Ryan Reynolds' interrogatories because he was dismissed from the case. And most of the claims were dismissed with prejudice. And even though Ryan has been dismissed, and they know he's been dismissed, Ryan is still trying to get documents from them, even though it's dismissed, which is weird because Leslie Sloan, who has had outstanding subpoenas and motions to compel, has basically mooted those with the court and said she's been dismissed, so we don't need these subpoenas anymore. We don't need these documents anymore. And because it's dismissed, it's irrelevant. But apparently, Blake's just using Ryan's interrogatories to say they're not complying, which is just now at that point reaching. And Kevin took a minute to kind of mock her claims of this ongoing smear campaign, which I've told you is hilarious because it's litigation at this point. They say Miss Lively refuses to limit the scope of her interrogatories concerning claims and defenses in the actions and seeks to expand the scope of this interrogatory to the present because, according to her, Miss Lively's amended complaint alleges that the purported smear campaign is ongoing. However, the amended complaint allegations of an ongoing smear campaign are made on information and belief, and the pleading cites to the communications at issue. Furthermore, the interrogatory is not limited to the so-called smear campaign or even negative comments about Miss Lively. Instead, she demands the identification of any reporter with whom the Wayfarer parties have recently communicated about Miss Lively, which would include reporters seeking comments in response to statements made to them by Miss Lively's own counsel or spokesperson, to the extent those people are different. Calling her out for saying, if we're talking to the press, it's because you're talking to them too. She also claims the identities of reporters listed in the Wayfarer party's responses are inexplicably vague. To the extent that she is unable to identify such reporters, we suggest that her counsel send us an email listing any such reporters, and if possible, we will provide further identifying information. And then they talk about identifying content creators that, they've spoken to about Lively, Reynolds, the CRD complaint, the actions. And they said she sought to compel a response only from TAG, not any of the other Wayfarer parties. And it's Mr. Reynolds that wanted the information on the content creators. And it says local rule 33.3 restricts the scope of interrogatories to those seeking the names of witnesses with knowledge of information relevant to the subject matter of the action. And they claim that her letter violates rule 33.3. So they're asking them to deny it. Basically, that she's seeking information she already has, or the information she's received she doesn't like, so she's writing a letter to the court, and that Ryan doesn't get to compel anyone because he's been dismissed. And then she's relying on public statements that they will amend, but at this point, Ryan is not a party. And so if he's amended at some point in a later time, and if he's added to the amended complaint, and I don't know that he is, because on several of these claims, he was basically all but removed from this lawsuit. They'll have to go through like a new set of discovery based on the new allegations for their claims and defenses. So old claims and defenses have nothing to do with now because they can't claim defamation. And Ryan isn't claiming defamation. He didn't sue for defamation. He's not a party. He's not part of her lawsuit, but it certainly seems like Ryan is behind the scenes directing a lot of this, because why does Ryan want to know who said what to content creators if he was dismissed? It's like they still want to control the narrative. And it is hilarious that they think that this smear campaign is still going on when all of we're doing here is talking about her lawsuit and the silly mistakes and the ridiculous demands they're making and how they're acting in court. The fact that she just isn't giving anything up, and she doesn't want to show damages, and she doesn't want to show the text from Taylor, and yet still claims that Taylor was super involved. It's like she has to continue to find a way to change the narrative. So if Taylor says she wasn't involved, I'm going to amend my pleadings and say that she was involved, even more so. Blake is insufferable, so insufferable. But I am glad to see Wayfarer fighting back a little bit, getting a little bit more pep in their step. I have a feeling that things will get a little bit better from here. Finally, you have all been asking me to address issues related to the judge. I've talked about this before, and I will address this again. I don't want to live in a world of conspiracy theory, okay? I don't want to live in a world of corruption. Right now, Wayfarer has not sought to have anyone recused, okay? Also, they have not amended their complaint, so we don't know what's coming up next. There are definitely issues with some of his financial disclosures. There are definitely ties he has to the entertainment industry because of his brother. There are obvious connections between his brother and Salma Hayek. There are stocks that he owns with T-Mobile and other companies, but he's failed to recuse himself a number of times when he's been called to recuse himself in the past. There was a case that was reversed, and a ruling on a motion to dismiss was overturned related to Bank of America. It was an antitrust case with far bigger ramifications. His wife sold stock related to Bank of America. He didn't disclose the sale of the stock, and then he only made it after it was dismissed. And the appeals court said that there was impropriety, like a veil of impropriety. You can't have any presence of impropriety if you're a judge. Unfortunately, there are judges that have presided over cases for our elected officials that have also had issues as it relates to their own conflicts. And when the judge at issue becomes the conversation, sure, there's discussions about if they'll recuse himself. But I've said this before, is that right now it does nothing to have a conversation about it because it doesn't change where we're at. The only way they are going to file an appeal is if there's some sort of issue with constitutionality. I would think, like, say Judge Lyman decides that he is going to award treble damages based on 47.1. Okay. If that were to happen, I would suspect that they would immediately file an appeal to the appeals court because it's an issue of constitutionality and whether or not treble damages are allowed in federal court, which are commonly not. And the fact that there's issues with the fee shifting of this because fee shifting is not common in federal court. If they're going to file an appeal and all it's going to do is kick it back to Judge Lyman, they might be reluctant to file an appeal. And petitioning him and asking him to recuse himself, he's going to say no. So it's just another motion that wastes time and causes delays. And you generally need a compelling reason. And at this point, if they were to appeal the amended complaint now, the appeals court could do something like this. They could basically say they're going to throw out the entire case and say, we actually think he got it wrong. All of the claims should be dismissed, everything, and they shouldn't get any amendment. So they have to be really strategic, and they have to have grounds to prove that his motion to dismiss was granted because of his collusion with them, which they don't have other than a theory on the internet. So I don't want to spend time worrying about what I can't control. I just want to spend time on worrying what I can control or talking about what I can control. And also, I don't watch any other content creators on this topic for a reason. I speak to a couple creators, but the only creator that I watch consistently, and that's not even like every day, is Shasti Flaw. And that's because she's been in the middle of all of this and because I've had a chance to get to know her and I enjoy her content. Other than that, I don't watch other people's videos really that often. So I don't speak to it. And I think, just to be clear, there's been a lot of topics and conversations about different creators and how your opinions are of them. And I made responses early on about my disagreements with someone's take or no take or whatever. And I don't want to be in the middle of fighting with other creators because it doesn't do anything good for anyone. And I don't want to spend time, disagreeing if this creator says this or this creator says that, because it doesn't matter to me what people say. Watch who you want to watch and enjoy what you enjoy and do what you do. And if a creator says something, instead of leaving me a comment and asking me about it, just skip it. I don't really feel like talking about it. I appreciate everyone that contributes to the conversation, whether they're a large creator or a small one. And I hope you guys enjoy the ones that you listen to and you find those that you listen to be helpful. And just remember, there's room for everyone. So what are your thoughts about all of this? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thank you so much. Bye, guys.